interest. Well, yes.
Lordship, the land possession.
In this case, 10% amount to 7 crores.
70 crores.
That person comes to 70.
My kind submission.
70 crores.
In this case, Lordships, the land has not been taken possession. Furthermore, this land is not likely to be utilized because that village from where the people are going to be displaced, that also may not be there. So if the Lordship says we will drop the entire acquisition process, we'll drop the entire acquisition process.
Yes, kindly see page 108. The photos in the 108. Kindly see.
One more suggestion. Wherever land possession ನೀವು ತಗೊಳ್ತಾ ಇದ್ದೀರಿ ಅಲ್ಲಾದ್ರೂ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕಾ?
ಅಲ್ಲ ಯಾವ್ದು ತಗೊಳ್ಳಲ್ಲ ಮೇಲೋ, that is what the case. We don't want to take immediately because land is not required for some time, a couple of years also ಮೇಲೋ.
ಬಿಟ್ಟು ಹಾಕ್ಬಿಡಿ.
In fact ಮೇಲೋ, at the higher level, in fact,
Mr. Advocate General, you can't interdict alienation of the property. You will keep, there are cases on record of this court and on the record of the apex court which have come here also. For years you have not accomplished acquisition proceedings. You have notified, kept quiet, under various legislations. It has happened under CDA Act,
KDB Act,
AIDB Act, it has happened under Urban Development Authorities Act 87.
correct.
It has happened under House Sites Grant of House Sites Acquisition Act.
Correct.
There are some cases we have been seeing every day. You can't go on like that.
No, Malus, as a Lordship rightly point, instead of deviating the whole thing, Malus, kindly, any reasonable amount, we are saying 10%, Malus. The reason is we'll argue the main matter or merits immediately after
Now
vacation.
they have come out with, there is some difficulty which the Honorable Learned Advocate General has said, Additional Advocate General said, Secretary himself is saying, why can't you be also walk a few miles that side?
One submission, kindly see the interim order passed by this court. The learned HGP has submitted that in connected matters, this court has stayed the judgment and award of the reference court subject to deposit of 50% of the award amount along with accrued interest, statutory deposit, etc. Taking
That's
note
the
of
reason
that,
all they have been called. Now
one
they have
thing,
explained.
they have deposited the amount in most of the cases,
In many
and
cases
it is
they have.
withdrawn also.
But there are
Only
54 cases, sorry, there are 54 cases as Advocate General has stated. Out of 54, 50 they have deposited, they are permitted to withdraw. They wanted to discriminate with these 4 persons because they have not approached us.
No,
Can we see that?
submission.
One more.
Approached them
That
to
is the
seek
case of-
early release.
let him file
That way you
affidavit.
are saying.
Let him file
Can
affidavit,
we see,
my
my
lord.
lord, the
Let him
whole
file
entire
affidavit.
application which they are now contending. Now, my lord,
Let him file affidavit
entire
on that.
application, in entire application.
Let him file affidavit of
And
that action.
one
Yes,
more-
He's making
one more
allegation,
thing.
let him
You
file
paid,
affidavit.
you are paid.
They did not approach means, they did not approach with a request to release it
To
early.
release.
Reason, my lord, out of
Nothing, no
my lord,
aspirations.
286 cases, interim order has been passed. Out of that, my lord, 50 cases, when the amount is available, we released it.
On what basis?
No, the first come first basis
How?
it has been released.
How that can?
Initially, it has been done, it is a mistake on our part. It is a mistake, I admit that it is a mistake on our part. My lord, if this mistake is continue, entire project of the UQP is never going to be completed.
But ಕೆಲವರಿಗೆ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿ.
Well, if that is the reason, my lord, because of the exorbitant award, my lord, now the state is realized.
All right, ನಾವು ಒಂದು ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಇನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ. You
Please, Manoj.
deposit, Mr. Advocate General. when
We'll go by
20%
whatever your
20%
Lordship
deposit ಮಾಡಿ.
Lordship,
20%
my
deposit.
submission is where possession has not been taken, kindly accept 10% because we have not displaced people. And wherever, if suppose person has been displaced, we agree to your Lordship.
ಅಲ್ಲಿ
direction.
25% ಮಾಡಿ. ಎಲ್ಲೆಲ್ಲಿ ಪೊಸಿಷನ್ ತಗೊಂಡಿರಿ 25%. ಎಲ್ಲೆಲ್ಲಿ ಪೊಸಿಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲೇ 10%.
But again, it should not be lead to any
Here-
misconception.
They are depositing before the court.
Exponential increase. There is something what
Not
Secretary
one
said.
submission. They have to deposit before court. It is
No,
not
no,
the
no.
payment.
ನೋಡಿ,
So even
ಅದು
they
ಇಲ್ಲ,
are not ready to.
ಅದು ಇಲ್ದಂಗ್ ಮಾಡ್ಕೋಬಾರ್ದು ನಾವು. ನೀವು ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ಇದ್ದೀರಿ. Contempt is any standard book on law of contempt would say it's a slippery jurisdiction. Who will slip when nobody knows.
No, even
Court itself is a matter of slippery
even in
jurisdiction.
compliance, there is a
One thing.
discrimination. Even in compliance of interim orders, there is a discrimination.
Lord, if
That is the
We'll
difference.
come to that one. It is not that amount is, you see, we
No,
will,
withdrawn.
or else you be ready to argue this
Please,
matter.
we state want my lord, state want early disposal because it's guide the entire nation also. Because section 26 is not interpreted by any of the High Court.
Now,
All
today
this
your
problem
lordship-
has come because of the interpretation of section 26.
The
my lord.
lordships
Today
kindly,
your lordship has disposed.
the.
Namaskara, madam.
Submission, my lord.
How ನೀವು ನಮಸ್ಕಾರ?
La, la, la. The interim orders which have been passed so far have not been finally adjudicated. None of these appeals have been taken up on merits. So only interim orders is giving so much of extra benefit to the people that they are not interested in pressing the matter at all. And they are allowed to withdraw. It is leading to travesty of justice.
ಈಗ 10% ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ do you allow them to withdraw? 10%? No, we are asking you, we do not know. We are just asking you. The escalation apparently, going by our poor arithmetics, escalation is exponential. It's exponential. That being said, we feel ಈ 10% ಇದೆಯಲ್ಲ, ಈ 10% ಅನ್ನ ಕೊಡ್ಬೋದು ಅಂತ what Mr. Advocate General, what do you say?
Well, I understand where your lordships are coming, but only thing tomorrow, if that is also set aside, some
Against
security or
guarantee,
some-
one more thing,
Please.
against guarantee.
Please, my lord, that would be subject to, I think that should be,
Indemnity bond.
ಇದಕ್ಕೂ ಕೊಡ್ತೀವಲ್ಲ.
subject to guarantee, my lord.
ನೀವು ಗ್ಯಾರಂಟಿ ಕೊಡ್ತೀರಾ? ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಅಮೌಂಟ್ ಕೊಡ್ಸೋಣ.
It is indemnity bond. We
ನಾಳೆ
have
ನೀವು
to-
10%
we have to
don't-
execute indemnity bond.
How? What we should do with the indemnity bond? You suppose you consume, you exhaust that money, where the government should go. That is the worry of the secretary.
So we will be
Secretary
more.
appears for all people of the state now. You hold brief only for few. Of course, your rights are your rights only.
If 25% is deposited, we are ready to give the guarantee for amount.
25% is your lordship.
25% ಗ್ಯಾರಂಟಿ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ನಿಮ್ಗೆ, 10% ಕೊಡಕ್ಕಾಗಲ್ವಾ?
ಅಲ್ಲ 10%
10%
ಕೊಡ್ತೇವೆ.
is-
ಕೊಡಿ,
But-
ಮುಂದೆ ನಿಮಿಷ ಕೊಡಿ. 10% ಕೊಟ್ಟ ತಕ್ಷಣ ನಾವು another 5 years ನಾವು ಇಟ್ಕೊಂಡು ಕೊಡಲ್ಲ. From 20, ಯಾವತ್ತು reopening is on 14th?
14.
14th.
14th we are hearing these matters.
Please, my lord. We will be ready, we'll file a convenient compilation, we'll be ready for
Provided
arguments,
that-
my lord.
Provided that you will deposit 10% wherever possession is not taken,
In terms of,
Please.
my lord,
and
again, it's not-
20% wherever possession is taken.
Please, my lord,
And
please.
So rest of the things
please,
to the
Please,
rest.
grateful. We are
We'll be
very
ready with
grateful.
the arguments
We are grateful.
on the
My
14th.
request would be kindly hear the main appeal on merits and club all the cases of one particular village because they have absolutely the same logic which has been applied, doctrine of parity
Provided-
or otherwise.
Provide-
We'll do that, we'll
abide
comply
by
with the lordship's
court
order.
order.
Yes, yes.
If you do not pay, then on that ground we will dismiss the.
We humbly comply with the orders of the.
Small.
We'll comply with your lordship's direction, my lord.
14th ಇಂದ we'll start hearing the matter.
Absolutely no problem.
We will be ready, my
In
lord.
the meanwhile, 10% ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ, ಆ 10% ಅಮೌಂಟ್ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಒಂದು ಸ್ಮಾಲ್. ಅವರು ಪೊಸಿಷನ್ ಎಲ್ಲೆಲ್ಲಿ ತಗೊಂಡಿಲ್ಲ, ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದರಿಗೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಂಟ್ರೆಸ್ಟ್ ಬರೋದೇ ಪೊಸಿಷನ್ ತಗೊಂಡ್ರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡೋ ಪ್ರಶ್ನೆ ಬರಲ್ಲ.
ಅದು argue
ಅದಕ್ಕೆ ಫಾರ್ ದಟ್ ರೀಸನ್ ನಮ್ಗೆ ಅವಾರ್ಡ್ ಆಗಿ ನಾವು ತಗೊಂಡದಾದ್ಮೇಲೆ ಆ 10% ಕೊಡಲ್ಲ, ಬೇರೆಯವ್ರಿಗೆ 50% ಕೊಡ್ತೀವಿ ಅಂತ.
ನೀವು ಪೊಸಿಷನ್ ಕೊಟ್ಟಿರಾ, ಅದು ಬಿಡಿ, ಅದು ಆರ್ಗ್ಯೂ ಮಾಡಾಗಿದೆ. It is already argued. Don't repeat anything.
ಅಲ್ಲ.
We have that also in mind.
Yes, that is why what my request.
Any other
Lordships,
point?
you lordships
Any
are
other
taking-
point? Any other point?
We are at the hands of you lordships.
You are only repeating.
No,
That
no,
not
no,
help us.
we are at the hands of you lordships. Can
ಏನ್
you
ಬೇಡಪ್ಪ,
consider-
ನೋಡ್ರಿ ನಾವೆಲ್ಲರೂ in the hands of law.
No, but
ನಾವ್ ಇಲ್ಲಿದ್ದೀವಿ, ನೀವ್ ಅಲ್ಲಿದ್ದೀರಿ, ನಮ್ಗಿಂತ
No,
more
no,
important ನೀವೆಲ್ಲರೂ.
Consider it that, Lord, you lordships, since you lordships are saying that.
ಬರ್ಕೊಳ್ಳಿ,
10%
ಬರ್ಕೊಳ್ಳಿ,
is-
you are wasting the time of the court.
Lord, that should not be possession or with possession.
Modification. Science. These appeals call in question the order of the reference court, arguably enhancing the compensation. Please be seated. Please be seated. ಕೂತ್ಕೊಳ್ಳಿ. In multiples. First stop. We had shown our red dice to the acquiring agency stroke beneficiary of acquisition on the other day for not making deposit of 50% of the award amount as enhanced by the reference court. In the appeals filed by the government or the agency concerned, laying a challenge thereto. First stop. The several contempt proceedings have been filed on the ground that the interim stay was subject to the government stroke agency depositing 50% of the compensation amount as enhanced by the reference court. First up. Whether such a contempt would lie or not is a matter of argument, and we will not say anything about that. First up, be that as it may. Next paragraph. On our request, the principal secretary, additional chief secretary, Department so and so is before us, and he has explained in a greater detail than was required as to what all has happened in the matter. First, he also said about the meetings having been held in the presence of Honorable the Chief Minister, the concerned minister, and other stakeholders in the matter. First up, learned Advocate General also made submission drawing our attention as to the arguable unjustifiability of exponential enhancement of the compensation. First off, learned Additional Advocate General also passionately made his submission. First off, we have heard from the landlords side as well. First off, truth lies. First, 1 second. The arguments appear to be bipolar. First, truth lies somewhere in between. Maybe this side more or that side more. First up, that we can ascertain when the hearing of the main matter would take place, before long, as is agreed by both the sides. First up. Next paragraph. Learned Advocate General, Learned Additional Advocate General, and the Learned Additional Chief Secretary, who is graciously present before us, submitted that the application seeking modification of the interim orders be favored. First off, that was vociferously resisted by the council representing the landlords. First off, they also raised an issue as to discriminatory treatment at the hands of the government, in the matter of depositing in the court and releasing the deposited amount of compensation in favor of some and not doing this in respect of others. First up, sometimes mistakes do occur, is the explanation offered by the Additional Advocate General, and we to some extent agree with the same. First up, that is not the end of matter. First up, next paragraph. Having heard all the stakeholders in the matter, we are of a considered opinion that the subject application supported by a narrative affidavit needs to be favored to a reasonable extent, and the requirement of depositing 50% of enhanced amount of compensation as done by the reference court below, needs to be a bit relaxed. First up, the Additional Chief Secretary said the reduction should be from 50% to 10%. And both the Advocate General and the the additional advocate general echoed the same, giving some reasons, comma, not totally irrelevant to consideration. First up, they highlighted possession is a factor even in deciding what should be the amount to be deposited. First up, they said amount to be deposited may be bit more when possession is already taken, and where possession has not been taken yet, comma, the reduction should be to 10%. First up. Next up, having adverted to all the we are also mindful of the fact that the project was undertaken way back in the year 2012, comma, much time has run since then, as also much water under the bridges. First up, the escalation element is also kept in view. First up, in the above circumstances, we modify the interim orders granted by the court to the effect that instead of as under to the following effect, A, wherever possession has already been assumed pursuant to acquisition process, comma, the requirement of depositing 50% of the enhanced amount of compensation is relaxed and downsized to, relaxed and the amount is downsized to 20%, 25%. And of that, 10% release ಮಾಡೋಣ 10% ಮಾಡ್ಬೋದಾ ಮಿಸ್ಟರ್ ಸೆಕ್ರೆಟರಿ? ಕುತ್ಕೊಂಡು ಹೇಳಿ.
10% release ಮಾಡಬಹುದು on against indemnity bond or some kind of guarantee.
Guarantee would be better, Manoj. Some guarantee if it's given, that would be helpful, Manoj, by chance, because the amount, Manoj, is 100 times more, Manoj.
100%
And one other aspect, Manoj, there are 613 cases before your lordships. The award is based only on one reference order, Manoj. So there's no valuation of the property at all. Only on LAC number 860.
We do not know. Let us see.
I'm sorry on that. I'm not going on merit, Manoj. My apologies.
ಎಷ್ಟು ಅಮೌಂಟ್ ಈಗ ಎಷ್ಟು ಅಮೌಂಟ್ ಅನ್ನ ಅವ್ರಿಗೆ ಕೊಡಬೇಕು, ಮೊಡಾಲಿಟಿ ಏನು ಅಂತ ಹೇಳಿ, ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ ರೆಫರೆನ್ಸ್ ಕೋರ್ಟ್ನಲ್ಲಿ ಮತ್ತೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್, ಬೇರೆ ರೈತರು ಇದನ್ನ ಮಾಡ್ಕೊತ ಕೊಡಕ್ಕಾಗ್ತಾವ, ಹೊಲ ಉಳೋದೆಲ್ಲ ಬಿಟ್ಕೊಂಡು ಬೇರೆ ಕೋರ್ಟು ಅವ್ನ್ ಸೆಲ್.
Correct. ಅರ್ಥ ಆಯ್ತು Manoj. Out of 25%, your lordship, 10% we will let them release against guarantee, Manoj, insofar as their possession has been taken.
Of this semicolon, of this amount, 10% of the enhanced amount, bracket nalli enhanced amount, of enhanced amount shall be released in favor of the land losers against they executing indemnity stroke guarantee bonds.
Indemnity bonds.
Yeah. Or indemnity is difficult to recover the money, Manoj. That's the
Guarantee.
problem.
ಹೆಂಗ್ ಮಾಡಿ ನಾಳೆಲ್ಲ ಮುಗಿಸಿ ಇಂಡಮ್ನಿಟಿ ಬಾಂಡ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ?
Land
We cannot do anything.
Land will be there.
Huh?
Lands are there.
ಕರೆಕ್ಟ್. ಆ ಲ್ಯಾಂಡ್ಸ್
ಇವತ್ತು 25 ಲಕ್ಷಕ್ಕೂ ಬಾಳಲ್ಲ ಅದು. ಇವತ್ತೇ ಬಿಟ್ಕೊಟ್ರೆ 25 ಲಕ್ಷಕ್ಕೂ ಬಾಳಲ್ಲ ಲ್ಯಾಂಡ್.
Land ಗೆ value
25 ಲಕ್ಷ. I told my lord, this land will be utilized in year 2050.
against the land losers, against execution, due execution of execution and furnishment of the bond of guarantee. Sentence ಹೆಂಗ್ ಮಾಡಿದೀನಿ ನೀನು ಮೇಲಿಂದ? Wherever possession has not been taken, comma, the requirement of depositing the amount would be 10%. Even semicolon, even this amount may also be withdrawn by the land losers subject to the same condition as above, as stipulated above. Stipulated above. Full stop. It is made clear. The amount to be deposited, the deposit of the amount shall be made. Yes, this tell Martiri. Within how many days you are doing that?
Within 1 month,
Huh?
within 4 weeks,
Last year. All contempts we are closing.
within 4 weeks.
Within 4 weeks. All right. Within 4 weeks, within 5 weeks, within amount shall be deposited within 5 weeks. Within 5 weeks. Failing which, as is suggested by the additional chief secretary himself. Suppose if it is not done, your appeals will go.
Your Lordship may dismiss it, my Lord. We will comply with it, my Lord.
We will comply.
If you don't comply,
We'll comply.
If you are complying, why are you afraid of our suggestion? Yes. Our suggestion, that will take, it will effectuate where you do not. And more often than not, you have not.
No, we undertake to comply with the orders of the court, and if the suggestion of honorable court is
Failing which the appellants are put to warning that the appeals would be treated as having been rejected.
sir, apologize, my Lords.
Yeah, in view of the above. Yes, Mr. AG.
We are sorry, my Lords, to troubling your Lordship for implement of the interim order, which is our duty to do it, my Lord. I took stock of all the cases, my Lord. I will see to that nothing happens. This such a situation
Now
doesn't.
we are just thinking, amount deposit, government difficulty. It's not that we do not appreciate. These are all budgetary aspects. Huge project. Very, as the chief secretary, additional chief secretary said, it's a huge mega project it is. In the above circumstances, the contempt proceedings are liable to be and accordingly dropped. With the right of renewal of the same in the event there is non-compliance. Adnu idana plus appeal hogli. Erdu illi. Non-compliance by moving a simple memo. Full stop. Next paragraph. All the observations herein above made being relevant, confined to disposal of these contempt proceedings shall not cast their light or shadow on the pending appeals, which shall be heard and decided on their intrinsic merits. Provided the compliance is there.
Please.
Compliance is there.
Deposit be made to before reference court.
The reference court.
The serial number 21 is another matter where you are not passed an award against the mandate of section 19. The learned single judge has directed, my lord.
No, of course. We appreciate the assistance rendered by learned additional advocate general, additional advocate general, and the additional chief secretary who graciously came all the way from Bangalore to Dharwad to assist, to participate in the, to effectively participate in proceedings.
Again, we sincerely apologize to your Lordships, my Lords.
Please from partner to next bench munda argument ಮಾಡ್ಕೊಳ್ಳಿ.
Please, let's.
Please form.
And
They are very happy at least.
No.
There are 613 cases.
They have shown the hands this side.
we respect and we express deep gratitude to the court, honorable court and lordships. You have saved this project, because if this project has to undertake all these lands acquisition at very high cost, it will by itself fail and it will derail the project. So ಇಷ್ಟು ಮಾಡಿದರಲ್ಲಿ ತಾವು ಸರ್ ಉತ್ತರ ಕರ್ನಾಟಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ರೈತರ ಒಂದು ಕಲ್ಯಾಣಕ್ಕಾಗಿ ಇರ್ತಕ್ಕಂಥ ಈ ಪ್ರಾಜೆಕ್ಟ್ ಅನ್ನು ಉಳಿಸ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಹೇಳಿ ತಮ್ಮಲ್ಲಿ ನಾನು ಕೇಳಬೇಕು.
ಉತ್ತರ ಕರ್ನಾಟಕದ ಜನರಿಗೆ ಒಂದೆಲ್ಲೋ ಒಂದ್ ಕಡೆ ಮನಸ್ಸಿನಲ್ಲಿ ತಮಗೆ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್ ಆಗ್ತಾ ಇದೆ ಅನ್ನುವಂತ ವ್ಯೂ, ಅದಕ್ಕೆ ಸ್ಕೋಪ್ ಕೊಡಬಾರ್ದು. ಅದು ನಿಜ ಸುಳ್ಳು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ಅನೇಕ ಜನ ನಾವು ಪಾರ್ಕ್ ನಲ್ಲಿ ವಾಕ್ ಮಾಡುವಾಗ ಹೊರಗಡೆ ಹೋದಾಗ, ಫಂಕ್ಷನ್ನಿಗೆ ಹೋದಾಗ, ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಆ ಆ ತುಂಗಭದ್ರಾ ನದಿ ಆ ಕಡೆ ಹೋದಾಕ್ಷಣ ಸ್ವಲ್ಪ ಬೇರೆ ನಮ್ನಿ ಇರ್ತದೆ, ನಮಗ್ ಬೇರೆ ನಮ್ನಿ ಆಗ್ತಾ ಇದೆ ಅನ್ನೋ ಫೀಲಿಂಗ್ ಇದೆ. ಅದಕ್ಕೆ ಸ್ಕೋಪ್ ಕೊಡಬಾರ್ದು. ಇಡೀ ಸ್ಟೇಟ್ ಇದನ್ನ ಕರ್ನಾಟಕ ಗತ ವೈಭವ ಆಲೂರು ವೆಂಕಟರಾಯರು ಬರೆದಿದ್ದು, ಇದನ್ನ ಒಗ್ಗೂಡಿಸುವಾಗ ಎಷ್ಟು ಜನರು ಕಷ್ಟಪಟ್ಟಾರೆ. ಇದಕ್ಕೆಲ್ಲ ನಾವು ಆ ರೀತಿ ಒಂದಾಗಿರ್ಲಿಕ್ಕೆ ಏನೆಲ್ಲ ಬೇಕದನ್ನೆಲ್ಲ ಜನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸ್ವಲ್ಪ ಸರ್ಕಾರದ ಗಮನನೂ ಸ್ವಲ್ಪ ಆ ಕಡೆ ಹೋಗ್ಬೇಕು.
ಖಂಡಿತ
ಸ್ವಲ್ಪ ತುಂಗಭದ್ರಾ ಈ ಕಡೆ
ಖಂಡಿತ ತಮ್ಮಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಅಭಿಪ್ರಾಯವನ್ನು ಮಾನ್ಯ ಸರ್ಕಾರಕ್ಕೆ
ನಂಜುಂಡಪ್ಪ ರಿಪೋರ್ಟ್ ಇದೆ, ಪ್ರೊಫೆಸರ್ ಡಾಕ್ಟರ್ DN ನಂಜುಂಡಪ್ಪ ಅವ್ರ ರಿಪೋರ್ಟ್ ಇದೆ. ನಾವೇನ್ ಹಂಗೆ ಹೇಳ್ತೀವಿ ಅಂತ ಇಟ್ಕೋಬೇಡಿ, ಸ್ವಲ್ಪ ಔಟ್ ಆಫ್ ದ ಕಂಟೆಕ್ಸ್ಟ್ ಆಗ್ತದೆ ನಮ್ಮ ಮಾತು, ಬಟ್ ನಾವು ಇದು ನಿಮ್ಗೆ ಅಲರ್ಟ್ ಮಾಡ್ಲೇಬೇಕಾಗ್ತದೆ. ಒಂದ್ ಸ್ವಲ್ಪ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಒಂದು ಅಂದ್ರೆ ಅವ್ರು ಅನ್ಕೊಳ್ಳೋದು ಎಲ್ಲೋ ಒಂದು
ಉತ್ತರ ಕರ್ನಾಟಕ ಮತ್ತು
ಫೀಲಿಂಗ್ ಇದೆ ಅವ್ರಿಗೆ. ಅದು ಸರಿ ತಪ್ಪು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಇದು ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ನಮ್ಗೆ. ಬಟ್ ನೋಡಿ ಇದರಲ್ಲೇ ನೋಡ್ತಾ ಇದ್ದೀವಿ, ಇದೇ ರೀತಿ ಇದ್ದಂತಹ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ಗಳನ್ನ ನಾವು ಹ್ಯಾಂಡಲ್ ಮಾಡಿದ್ದೇವೆ.
ಸರ್, ಉತ್ತರ ಕರ್ನಾಟಕ ಮತ್ತು ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಎಲ್ಲಾ ನೀರಾವರಿ ಪ್ರಾಜೆಕ್ಟ್ಸ್ ಅನ್ನು ಬಹಳ ಮಹತ್ವಪೂರ್ಣವಾಗಿರ್ತಕ್ಕಂಥದ್ದು, ಬಹಳ ದಿವಸದಿಂದ ಅದನ್ನು ಜನರು ಕಾದು ನೋಡ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸ್ತಕ್ಕಂಥದ್ದು ಒಂದು ಖಂಡಿತ ಒಂದು ನಿಲುವನ್ನು ನಾವು ತೆಗೆದುಕೊಂಡಿದ್ದೀವಿ, ಸರ್ಕಾರ ಅದನ್ನು ಮಾಡ್ತೀವಿ.
ಅದನ್ನ ದಯಮಾಡಿ ಮಾಡಿ. ಇದು ಬಸವಣ್ಣನ
serial number 21
ಮಾಡಿ, ದಯಮಾಡಿ ಮಾಡಿ.
serial number 21 where the award has not been passed.
21
so serial number 21 ಅಲ್ಲಿ ಅವಾರ್ಡ್ ಪಾಸ್ ಆಗಿಲ್ಲ. ಅದಕ್ಕೆ that my lord, that is also some policy decision is required to be taken. It may be, we are also filed a writ appeal.
One year. If they have not passed an award under subsection 3, my lord, there is a extension of time. Now, the learned single judge, following that provision and also referring the judgment of this honorable court, as your lordship has passed an order, and also division bench, they preferred an appeal, my lord, and also division bench order stating that, my lord, the award should, in the meanwhile, they have passed an award in that case, in the writ appeal. Now, here, my lord, in the November is the last date. If extended time limit.
14th ಈ ಹಬ್ಬ ಮುಗಿಸಿದ ನಂತರ ಫ್ರೀ ಆಗಿ
ಅಲ್ಲ, ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ಅವಾಗ ಅಷ್ಟು ದಿನದ ಒಳಗೆ ನಮಗೆ ಅವಾರ್ಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತಾರೆ. It vitiates. What happened, my lord? 2015, my lord, first acquisition proceedings is initiated. From 10 years, my lord, the farmers are the sufferers.
ಈಗ ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು, there is some point in what you are saying, we understand also. ನಮ್ ಸ್ವಲ್ಪ we are hard pressed for time. ಹಾಗಾಗಿ ನಾವೇ ಒಂದು ಅಜರ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೆ, ಅವ್ರದ್ದು ಬಿಡಿ, ಅವ್ರನ್ನ ತಲೆ ಕೆಡಿಸಬೇಡ್ರಿ. We are seeking adjournment at your hands now. Give one adjournment to us immediately after vacation, please. Call immediately.
Supreme Court says regarding contempt, my lord. So disregarding the court's order may be seen forward.
ಈಗ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ರು, ಸೆಕ್ರೆಟರಿ ಅಡಿಷನಲ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ವಾಸ್ ಹಿಯರ್.
This is different case, my
ಅವರೆಲ್ಲ
lord.
ನೋಡಿದ್ದಾರೆ. ನೋಡಿ ಮಾಡೋಣ.
Serial number 32.
Your lordship, kindly have it on immediate after vacation. 14th, my lord.
Immediately
14th.
after immediate 14th ಅನ್ನೋದು ಬೇಡ, ಸ್ವಲ್ಪ ಅವಾಗ ಇನ್ನೂ
On date fix ಮಾಡ್ಬೇಕು.
ಒಂದು 2 ದಿವಸ ಫಸ್ಟ್ ವೀಕ್
ಅಲ್ಲ, ಲ್ಯಾಪ್ಸ್ ಆಗಿ ಹೋಗುತ್ತೆ ಅದರ
ಆ ಟೈಮ್.
10 years.
ನವೆಂಬರ್ ನಲ್ಲಿ ಲ್ಯಾಪ್ಸ್ ಆಗ್ತದೆ. ಆಗಲ್ಲ.
ಅಕ್ಟೋಬರ್ ಅಲ್ಲಿ ಲ್ಯಾಪ್ಸ್ ಆಗಿ ಹೋಗುತ್ತೆ.
15th ಹಾಕೋಣ, ಬೇರೆ ಬೆಂಚ್ ಇದೆ ಅದಕ್ಕೆ.
Please.
15th.
My lord, serial number 32, my lord. My application is pending for direction to disbursement of amount. At least we'll get to the 10% as per direction of this honorable court, my lord.
ಅದು
In ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ ಸರ್. ಇದೆ 10% ಆರ್ಡರ್ ಮೇ ಬಿ ಮೇಡ್.
ಯಾವ್ದು?
In the connected case.
Serial number 32, my lord.
ಎಲ್ಲದರಲ್ಲೂ 10% ಮಾಡ್ಬೋದಾ? Please. Advocate General is also here, na?
Please.
In all these
ಮಾಡ್ಬೋದು ಸರ್.
Only in the matters which are before your lordships, my lords.
that's what.
ಡಿಲೇ ಆಲ್ರೆಡಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಅಪಿಯರ್ಡ್.
The interim order, order dated so and so, you are passed in so and so. State into judgment and award of the citizens court subject to appellant state depositing 10% of the amount which is permitted to be released in favor of the landowners in terms of the order dated so and so. Correct? Deposit shall be made before the reference court within a period of on or within the same 5 weeks. Same guarantee.
Same.
In all these matters, interim order illala.
Okay, 10%.
Please, greatly obliged.
Grateful to my lords.
Very, very, okay.
Being spoken cost
ಕೊಡ್ಬೇಕು.
beneficiary of the appeal. Partially allowed.
ಸ್ಟೇಟಿಗೆ ನಾವು ಇದು ಇಲ್ಲ. ಸ್ಟೇಟ್ ಅಪೀಲ್
State ಅಲ್ಲಿ authority.
ಅಥಾರಿಟಿ ಇದೆ, ಅವ್ರದ್ದು ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕು.
So
ಹೌದು ವಾಪಸ್ ಹೌದು
ಏನಂತ
ಸ್ಟೇಟಿಗೆ ಹೋಗ್ಬೇಕು.
reason ಏನ್ ಮಾಡೋದು?
No, when it's brought to this is your system.
By order dated 7. That disposed of appeals. However, while disposing the appeal, court order, no order as to cost. Said order
Along with cost.
and by inadvertence. Considering the fact that appeals filed by the authority as well as the landowners are hardly allowed, these appeals are disposed of with costs. The registry shall make
Yes, Your Lord,
correction in the
Wherever the court fees are paid, in some cases they are not paid. That's clarify ಮಾಡ್ಬಿಟ್ಟು.
This will apply wherever court fees are paid.
Yes, sir.
This applies wherever court fees are paid.
Yes, sir.
Accordingly, memo is disposed.
Yes.
Yes, brother.
One date may be fixed, my lord.
Ready ilva?
Lord,
2007 matter.
Last
ಏನು
time, 23/7, my lord, 23/7, they released the order, my lord, 33 hostel workers, Wims matter, my lord. ತಮ್ಮ ಮುಂದೆ ಪಾರ್ಟೆಡ್ ಆಗಿತ್ತದ, 23/7 ರಿಲೀಸ್ ಆಗಿದೆ.
ರಿಲೀಸ್ ಆಗಿದೆ.
ಬೆಂಗಳೂರಲ್ಲಿ ಇತ್ತು, ಈ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಬಂದಿದೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್. 2007 ಇಸ್ವಿ ಮ್ಯಾಟರ್.
ಹೌದು.
ಏನ್ ಅನ್ಕೋತಾರೆ ಲಿಟಿಗಂಟ್ಸ್ ನಮ್ ಬಗ್ಗೆ? ನಿಮ್ ಬಗ್ಗೆನೂ ನಮ್ ಬಗ್ಗೆ ಏನ್ ಅನ್ಕೋತಾರೆ ಅವ್ರು?
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹಾರ್ನಳ್ಳಿ ಸ್ವಾಮಿ ಅವರು ಅಟೆಂಡ್ ಆಗಿತ್ತು.
ಯಾರ ಬರ್ಲಿ ನಮ್ ನೋಡಪ್ಪ, ಎಲ್ಲರಿಗೂ ನಮ್ ಗೌರವ ಇದೆ. ನೀವು 2007 ಇಸ್ವಿ
2023/7 ರಿಲೀಸ್ ಆಗಿದೆ, ಪಾರ್ಟೆಡ್ ಹರ್ಡ್ ರಿಲೀಸ್ ಆಗಿದೆ, ತಾವ ಮಾಡಿದ್ದು ಸ್ವಾಮಿ.
ಆಗ್ಲಿ, ಈಗ ನಮ್ ಮುಂದ್ ಬಂದದಿಲ್ಲ.
One date may be fixed.
Kindly, my lord. Respondent 15 died, my lord. We file memo.
15 respondent.
Respondent 15, my lord.
15.
Yes, my lord.
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ನಾನು
No, memo, my lord. They will.
ಅವ್ರಿಗೆ ರಿಪೋರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Yes, my lord.
ರಿಪೋರ್ಟ್ ಮಾಡೋ ಬದ್ಲಿ ಒಂದ್ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ರೆ ಕೇಸ್ ಬೇಗನೆ ಮುಗಿಸಕ್ ಬರ್ತಿತ್ತ. ಮತ್ತ ಅದ್ರ ಮೇಲೆ 1 ತಿಂಗಳು 2 ತಿಂಗಳು ಹೋಗೋದು.
No.
ಎಷ್ಟ್ ದಿವಸ ಎಷ್ಟ್ ಜನ ಸತ್ತ ಹೋಗ್ಬಿಡ್ತಾರ. ಈಗಾಗ್ಲೇ ನೋಡ್ಕೊಂಡ್ರೆ ಎಷ್ಟ್ ಜನ ತೀರ್ಕೊಂಡಾರೆ ಅನ್ನೋದು.
The Krupanand advocate is different, my lord.
Respondent number 15 is reported to have died. First off, to this effect, the council has filed a memo. First, steps to be taken by the appellant immediately. Okay. Call this matter in the 3rd week of October.
Yes, my lord.
As requested. Yes, Shivraj.
Matter, my lord, earlier, my lord, it was directed, pay, my lord, 250,000 rupees, deposit 250,000, the first installment. The last occasion, my lord, only 130,000 was paid. But remaining amount, my lord, my party has got the amount.
Paraplegia.
He was, my lord, directed to appear before the.
After 1 month. Medical board ಮುಂದೆ ಹೋಗಿದ್ರಾ?
ಹೋಗಿದ್ 1 month ಆಗಿಂದ ಹೋಗಂತ ಡೈರೆಕ್ಷನ್ ಇದೆ ಮಿಲಾಟ್ಸ್ ಇಲ್ಲಿ.
ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ?
ರಿಪೋರ್ಟ್
ಬಂದಿಲ್ವಾ?
ಇನ್ನ ಬಂದಿಲ್ಲ. 1 month ಆಗಿಂದ
ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದೊಂದು ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ವಾ? ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗಿದ್ರು ನಾವು ಕೇಳಿ.
ಒಂದ್ ತಿಂಗಳು ಇನ್ನ ಹೋಗಿಲ್ಲ, ಒಂದ್ ತಿಂಗಳು.
ಮತ್ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗಲ್ವಾ?
ಒಂದ್ ಮಂತ್ ಆಗಿಂದ ಹೋಗಂತ ಹೇಳಿದ್ರೆ ಇವಾಗ ಹೋಗ್ತಾರೆ ಸ್ವಾಮಿ.
ಸೆಕೆಂಡ್ ರಿಪೋರ್ಟ್.
2 days my lord, 2 days ಬಿಟ್ಟು.
Balance amount my lord is got. Last time 1,30,000 was paid. Another 1,20,000 my lord he has. I'll stare my lord. ಕೊಡ್ತೀವಿ.
Counsel appearing for the appellant's circumstance. Where the appellant is paying fees.
1,20,000 more.
1,20,000 cash to the parents who are present before the court. Accordingly, the appellant has handed over cash of rupees 1,20,000 to the appellant's side.
Appellant. Claimant's father and mother.
Respond.
Appellant's sister.
Respondents.
Respondents.
Respondent. They are respondents.
Sorry. Respondent. Naveen is injured.
Injured.
Please.
Respondent. The parents of the respondent. Respondent who are present to the parents of the respondent. They acknowledge the receipt of the same. Amicus, learned counsel appearing for the respondent, submits that within a period of 2 days' time, the parents will take the respondent Karnataka Institute of Medical Science Hubli for further examination as per the medical board's advice. The said submission is placed on record. List.
Please.
After the list of science ಆಟಾಡಿಲ್ಲ
ಮಾತಾಡಿ.
ಅದವ್ರಿಗೆ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ಸೈನ್ ಮಾಡಿ.
ಪ್ಲೀಸ್
ಲಿಸ್ಟ್ ಯಾವಾಗ
ಮಾಡಿಲ್ಲ
ಕೊಟ್ರ ದುಡ್ಡು ನೀವು ಕೌಂಟ್ ಮಾಡಿಸಿ.
ಪ್ಲೀಸ್
ಇದೆ
ಸೈನ್ ಮಾಡಿಸಿ.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
My lord, this is appeal preferred by this company challenging liability as a quantum. So far liability is concerned in view of the Mukund Jawan, it does not survive, my lord. Mukund Devangan. Yes, my lord. Vehicle involved accident is in a light goods vehicle. The driver is authorized to drive LME non-transport. Like LGV, light goods vehicle. The LME non-transport.
Is a transport vehicle, no?
It is a transport
But
vehicle.
that makes no difference now.
No, it doesn't.
ಏನಿದೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನಿದೆ ಹೇಳಿ.
And quantum is against quantum, my lord. There is small narrow compass between the claimant and insurance company that, as per the document issued by the town municipality Chanagiri, he was working as an Paura Karmika and drawing the salary of 6,162, my lord. As against tribunal has taken the income at the rate of 7,000.
2015.
15, my lord. ಅದು ಒಂದು ಪ್ಲಸ್ ಇದ್ರ ಮೇಲೆ ಅಂದ್ರೆ ಅಡಿಷನ್ 50% ಮಾಡಿದ್ದಾರೆ. 42 years old, 42 years old, my lord. Future prospects 50% ಮಾಡಿದ್ದಾರೆ.
ಫ್ಯೂಚರ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
50%, my lord.
ಟ್ರೈಬ್ಯುನಲ್.
ಹೌದು, my lord.
ಕರೆಕ್ಟ್ ಈಸ್
25%. We'll give the calculation, my lord. Only ತಾವು ಇನ್ಕಮ್ ವೆದರ್ 6,000 ಅಲ್ಲ 6,162 ತಗೋಬೇಕಾ 7,000 ಅಂತ ತಾವು ಹೇಳಿದ್ರೆ ಅದಲ್ಲಿ ಫೈನಲ್. We'll give the calculation. ಆಯ್ತು, my lord. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡಿ. ಸೀಟ್ ಕೊಡಿ.
I represent Dharani. Next week, his wife is not well, my lord.
Not well.
My lord's claimant's appeal seeking enhancement of
I appear for respondent, records are necessary. Even I have not filed wakalat, my lord. Take notice matter.
Against the order passed by the learned single judge, my lords. They had preferred, my lords, the corporation, my lords. The Buddha, my lords, had filed a writ appeal. That was also dismissed. Against that, my lords, they had approached the Supreme Court, filed an SLP. That was also dismissed, my lords, on 17th of this month. On the last occasion, my lord, this honorable court had directed for compliance or else bring an interim order from the Supreme Court. They had informed that the matter is pending before the Supreme Court.
My lord, I'm filing a counter affidavit. Counter affidavit. My lord.
What is the direction?
My lord, sir. Page 23 of the content. The
To
contempt.
allot alter site.
The land was acquired. There was a scheme, my lords, which says that either you receive compensation or they'll allot me an alternative site. I chose for an alternative site. And there was also an allotment in my favor.
Huh?
My land was, my lords, acquired for forming of a residential layout under a scheme called Scheme 40. Under that scheme, my lords, there was an option to either to receive the compensation amount or, my lords, for opting for an alternative developed site.
What have you done?
My lord, it was the contents of this respondent.
You have lost appeal. You have lost SLP.
Yes, yes, I know.
Both have gone. Now.
My submission is, this is the point to file a review petition before Supreme Court. Review petition.
Review petition.
Review petition.
ಹಾಕೊಳ್ಳಿ ನೀವು.
No, this case is custom, my lord. In the implement, this London single judge order, there was no time, period was fixed for compliance. Time limitation was not there. And this regard, this honorable court has passed two orders. When the time limit is not fixed, this contempt is not maintained.
ಯಾರು ಕಂಪ್ಲೈ ಮಾಡಬೇಕು?
Buddha.
CW Shakul Ahmed.
No, she is, now presently is working.
He is presently
Yes.
working.
Accused number 1 is transferred.
Keep her present tomorrow.
Yes, please.
Accused number 2 is directed to be personally present before the court to answer as to why there is apparently a blatant non-compliance of the order of the learned single judge, as affirmed in the appeal, and the SLP of the respondents having been negatived by the apex court.
Day after tomorrow.
Day after tomorrow. Personal presence may not be necessary if in the meanwhile order is complied and report is submitted to this court 2 days after tomorrow. Thursday, correct? Thursday. Tell her otherwise.
No, now we are not only seeking to extension of time. Only review is being to filed. That's why I am asking for time.
You have filed appeal, you have filed SLP. Now we are seeing more than what IE is meeting. Anyway.
Please.
You know, deliberately ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಆ impression ಇದೆ ನಮಗೆ. Yes. Yes.
I am appearing for the complainant. In fact, the order passed by the learned single judge.
What is the order?
To issue appointment orders in favor of the petitioner and to Malad. In fact, page number 24.
Any
Government is saying that Malad.
Filed against this?
It's there, connected.
Malad,
But,
connected
with
appeal,
respect to
writ
this
appeal.
order is concerned, but already contesting respondent has complied.
Complied.
Complied, madam.
Not complied.
Comply ಅಂದ್ರೆ please.
Yes.
Order compliance ಅಂದ್ರೆ with and substantial compliance ಆಗಬೇಕು. ಏನಂತ ಇದೆ order?
Running page 23.
23.
Yes.
All. Writ petitions are allowed, rejection list dated so and so is quashed. Consequently, order of appointment annexed the date so and so issued in favor of the private responsibility so and so, approvals issued by so and so, confirming of so and so response are quashed, a direction is issued to the fifth and sixth respondents to consider the case of the petitioner for appointment to the post of English teacher in the sixth respondent institution run by the fifth respondent institution and issue appropriate orders. ಯಾರು 5, 6 ಯಾರು?
Not either or principal Karnataka Rural Education Society and
Ask them to be present before the court.
our serve agide. No, they are private.
In spite of
Private. Private ಇದ್ರೆ ಇರ್ಲಿ, ಮೊದಲು ಬರ್ಬೇಕು ಅವ್ರು.
Serve agide.
ಕೇಳಿ.
And moreover, my lord, I have produced the appointment order. My lord, set aside with the learned single judge. He paid appeal, that is also with.
Appeal is here.
Either connected. Mr. Halikeri. Halikeri.
ಮೃತ್ಯುಂಜಯ. ಈಗ ಆಸ್ ಆಫ್ ನೌ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು, ಹಂಗೆ ಕಂಟೆಂಪ್ಟ್ ಹೋಗಿಬಿಡ್ತದೆ. ಮುಂದೆ ಮೇಲ್ ನೀವು ಅವ್ರ ಅಪೀಲ್ ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ.
Contempt, my lord.
The
It's
allegation
only, my lord,
in the contempt case is, the complaint in the contempt case is as to non-compliance of a learned single judge's order dated so and so rendered, dated 7/6/2023, rendered in complainant's WP number 115599 of 2019, connected with 100293 of 2022. First, relevant portion of the impugned order, the subject order reads as under 24 nalli. This tag. Next paragraph. The learned GA appearing for the official, appearing for respondent numbers. Fourth respondent state submits that the order has been substantially complied with by issuing appointment order by the management itself on
4/11/2023.
4/11/2023. First off, he also answers the grievance of the complainant that there should be approval to this order, saying that there is no such direction. First off, a perusal of the papers shows that this submission is right.
my lord.
First off, ಎಲ್ಲಿ ತೋರಿಸಿ ಡೈರೆಕ್ಷನ್ ಫಾರ್ ಅಪ್ರೂವಲ್.
ಅವರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿರೋದೇ ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಪ್ರೂವಲ್ ಆಫ್ ದಿ ಅಥಾರಿಟೀಸ್.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಪ್ರೂವಲ್ ಮೀನ್ಸ್ ಇಟ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಯು. ವಿತೌಟ್ ಅಪ್ರೂವಲ್ ಕೊಡ್ಲೇಬಾರ್ದಿತ್ತು ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿದೆ, ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಂತ ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಅಪ್ರೂವಲ್ ಮೀನ್ಸ್ ದೇರ್ ಇಸ್ ನೋ ಡೈರೆಕ್ಷನ್ ಫಾರ್ ಅಪ್ರೂವಲ್. ನೆಕ್ಸ್ಟ್ paragraph. We are having heard learned counsel appearing for the parties and having perused the complaint papers, we are of the considered view that there is with and substance compliance of the writ of the learned single judge,
In fact,
and therefore we drop these proceedings. First off,
my lord, in fact,
the issuance, we make it clear that the issuance of the appointment order is subject to result of the companion appeal in appeal number so and so Okay. Call immediately after application. Idu drop ಆಯ್ತು appeal ಅನ್ನ call out.
And in fact, my lord,
Next.
it is, my lord, subject, the appointment order, my lord, so issued, my lord, it's
Next.
My lord, in this I appear on behalf of the, on request made by the learned AG. On the last occasion, the lordship has passed an order directing the learned AG to file the statement with regarding to wherever the Gairana lands have been granted to the, throughout the state, and to make a affidavit before this court.
ಎಲ್ಲ ಅವರು defense people, they
yes.
have guarded our frontiers.
Yes.
You can't treat the defense people, ex-defense people that derogatively. We don't allow that.
Yes. Or on request, my lord, it can be taken tomorrow.
Tomorrow.
AG or illa.
Tomorrow.
Yes.
Call this matter. Reluctantly, request for adjournment is favored. Call this matter a day after.
Please. Please.
ಅವತ್ತು ಹೇಳ್ಬೇಕು
ಇಲ್ಲ
ಕಂಪ್ಲೇಂಟ್ ಇವೆಲ್ಲ ಸೋಲ್ಜರ್ಸ್ ಅನ್ನೆಲ್ಲ ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ನಾಳೆ ಯಾರು
yes.
ನಿಮ್ಗೆ ಒಪ್ಪಲ್ಲ. ಓಕೆ.
For the complainant. Pay protection.
I made an
of
attempt to secure any bilateral agreement. I could not get anything.
On the point, my lords, there are two judgments. One of the Honorable Apex Court, my lord, 2003.
It cannot be less than the last pay drawn on.
Yes, my lord, Supreme Court specifically says, I'll just read and pass on, my lord. The intention, there was no intention to protect any particular scale of pay. That being the position, the demand for a corresponding pay scale has no rationale. The High Court was therefore clearly in error in holding that scale of pay was the determinative factor. This is what has been urged by my learned friend. Yes. And with my lord's kind permission, my lord, one judgment of the Kerala High Court single bench, which deals with the particular provision which my learned friend read.
Shared a copy of the
in advance, much in advance, I have shared.
Kerala High Court. They were sent to two Supreme Court judgments. Kerala High Court. Okay. Yeah. Yes.
ನಾಳೆ ಕಂಪ್ಲೈ ಮಾಡಿ tomorrow.
I may be permitted to rely on the single bench judgment.
Why persuasive? After that Kusum in God, any judgment on central law will be binding on all high courts, subject to some exceptions.
Particularly because that judgment considers the very 2.1
comply
note.
That judgment, I can argue the matter based on this judgment also, my lord.
And one more clarification, sorry.
Now it's also, I am ready to argue the matter.
Only one clarification, sorry. ಅದ್ರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿದ್ರು, ರಿವರ್ಸ್ಡ್ ಮಾಡೋದು, ಡೈರೆಕ್ಟಿಂಗ್ ಫಾರ್ ರಿಕವರಿ. Now Supreme Court has stayed that. That also I have to place it on record. I should not only rely on one judgment which is passed.
Pending before the
Supreme Court now. Ali the recovery is stayed.
All correct. Recovery stayed ಅಂತಂದ್ರೆ matter is being examined by the Supreme Court ಅಂತ ಆಯ್ತಲ್ಲ.
Yes, yes. That also I have to place.
Suppose Supreme Court, the recovery is on the premise
that
contrary to yours.
Yes, yes.
Contrary to argued premise.
Yes.
ಹಂಗಾಗಿ ವೇಟ್ ಮಾಡಿ. ಮತ್ತೆ ಹಂಗಿದ್ದ ನಾವು ಹೆಂಗ್ ಡಿಸೈಡ್ ಮಾಡಿ?
But earlier Supreme Court judgment is very clear, my lord.
No, ಅದನ್ನ ಹಂಗಿದ್ರೆ Supreme Court ಯಾಕೆ ಹಂಗೆ ಹೇಳ್ತು?
2003
we are told that against the order of the learned single judge, the writ appeal was filed and dismissed, and against the said dismissal, SLP Heli number is pending consideration on the file of the apex court of the country. And further that there is a direction. Kerala High Court ಮೇಲೆ appeal ಹೋಗಿ SLP.
ಹೌದು ಹೌದು ಅಲ್ಲಿ ಹೋಗಿದೆ. ಅದಕ್ಕೆ that's what I was more not our more this thing.
Even then it requires consideration because identical matter is the same.
My lord, para number 12 of the judgment.
The point being argued before us, comma, we are told, comma, is being debated on the floor of the apex court. In a case arising from Kerala High Court.
SLP copy.
In SLP High Court, first off, in SLP number 8223 of 2020, a 3-judge bench of apex court has issued notice and interim order staying recovery from the petitioners from the ex-defense personnel, from the ex-defense personnel. In view of that, the hearing of this matter is deferred sine die, and it's open to the parties to seek posting after the disposal of the said SLP. Yes, Mr. Misale.
Please, Milords. Milords, the petitioner's land has been occupied. Petitioner's land has been occupied in the
Issue
year
preliminary notification.
without issuing
Come
preliminary.
to page 25. Acquire the land. No appeal is filed against this order. Yaru?
No, my lord.
Notice. Sure. Notice. How can this kind of order be passed? Apex Court said in 86, Justice C.S. Venkatramaya, there cannot be a direction for acquiring the land. Anyway. Yes.
My lord, we have lost the land in the year 1989.
Damages
Since then,
acquire ಮಾಡಿ ಅಂತ ಹೇಳ್ದಂಗೆ, it's a power of eminent domain. Eminent domain should be exercised by the executive, not by the judiciary. Anyway, let us, it's not in. Yes.
This, there is compliance modes. We have complied.
Compliance is done.
Please.
Both the sides submit very fairly that the order whose violation is complained of has been complied with. And a check for a sum of rupees 6 lakh,
60 lakhs.
60 lakh has been handed to the complainant by the letter dated 19/9/2024 issued by the special SLAO KIDB. First, in view of the above, these proceedings are liable to be and accordingly dropped.
One correction, Lord. It is credited to the complainant's account, Lord, through RTGS.
Complainant's account.
Please, account the lakh.
Check badli by RTGS.
Please.
RTGS payment are structure. Okay?
Please.
Next.
Please, Your Lordships. Please, Your Lordships, on the last occasion, Your Lordships were pleased to hear me on the merits of the case, Your Lordships. The matter is covered by the
3,455 days, my lord. Copies are given to you last week, my lord. File objections.
Notice, no notice has been given, Milords. To proposed respondents, notice has to be given.
Notice ಹೋಗಬೇಕಾಗ್ತದೆ.
Notice
But there is an inordinate delay, my lord. 3,455 days.
ಅದಕ್ಕೆ explanation ಇದ್ರೆ?
I4 of 24 minutes.
I4 of?
24.
ಎಲ್ಲ ಏನು?
All I's, 1 to 4 of 24.
May I pass on the memo, my lords?
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಅವ್ರಿಗೆ ಕಬ್ಜಾ ಕೊಟ್ರ ನಿಮ್ಗೆ?
Quotas. Quotara. What they are trying to interpret is, court has directed them to give the position. They themselves have undertaken to give the position.
ಪಾಪಿಗ ಆಫೀಸರ್ಗೆ ಆಮೇಲೆ ಆ ವಿಡಿಯೋದಲ್ಲೆಲ್ಲ ಕೆಲವು ಕಡೆ ಬರ್ತಾರೆ ಆ ರೀತಿ ಕಳಿಸಿದ್ರೆ ಏನೋ ಒಂದು ಡಿಸ್ಕಷನ್ ಮಾಡ್ತಿರ್ತೀವಿ. ಹಂಗೆಲ್ಲ ಬರೆದ್ರೆ ಹೆಂಗ? ಹೌ ದಿ ಆಫೀಸರ್ ಶುಡ್ ಫಂಕ್ಷನ್ ಟುಮಾರೋ. ಅವೇನೋ ಒಂದು ಜಸ್ಟಿಸ್ ಮಾಡಕು ಅನ್ನೋದಕ್ಕೆ ಒಂದು 4 ಮಾತು ಮಾರ್ತಿರ್ತೀವಿ.
Intention of this court is to get the.
ಹಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಒಳ್ಳೊಳ್ಳೆ ಆಫೀಸರ್ಸ್ ಮುಂದೆ ಗತಿ ಏನವರು?
Including advocate.
ಈಗ ಪೊಸಿಷನ್ ಕೊಟ್ಟಾಗಿದೆ, ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿದೆ. Compliance in the sense they have given back the land to you.
Land. And only thing is, damages have to be given. Because they have.
ನೀವು ಹೆಂಗ ಡ್ಯಾಮೇಜಸ್ ನೀವು ವರ್ಕೌಟ್ ಮಾಡ್ಕೆ ಹೋಗಕ್ಕಾಗ್ತದೆ.
ಮಾಡ್ಕೊಂತೀವಿ, but that liberty is already there in the earlier order.
ಆ ಪ್ರಕಾರ ನೀವು ಮಾಡ್ಕೆ ಹೋಗಕ್ಕಾಗ್ತದೆ.
ಮಾಡ್ಕೊಳಕ್ liberty, and we may approach the high court also, not civil court ಗೆ ಹಾಕಿದ್ರೆ ಮತ್ತೆ 20 ವರ್ಷ ಹೋಗುತ್ತೆ.
ಅದು ಹಂಗನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಈಗಾಗಲೇ
ಯಾಕಂದ್ರೆ ನಾವೇನ್ ಹೇಳಲ್ಲ 300 ಕ್ಯಾಪಿಟಲ್ ಏನು ಇದೆ ಅಲ್ಲಿ. ಅವಾಗೂ ಸಹಿತ ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾ ಅಥವಾ ಹೈಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾ
Yes,
ಇದನ್ನೆಲ್ಲ
that
ನೋಡ್ಕೊಳ್ಳಿ.
liberty
We do
may
not
be
know.
reserved.
Learned panel counsel appearing for the answering respondents have filed a memo this day. This day. Along with 3 copies of documents accompanying the same. First of the documents is Panchanama, comma. Second is of delivery of possession of the subject land to the complainant. And third one is the photograph in which the respondent commissioner of the local body and the respondent jurisdictional assistant commissioner do figure.
And also managing director, Smart City Corporation.
Comma, in addition to managing director of Smart City Corporation. First off. Next one. In view of the above, the contempt proceedings are liable to be closed and accordingly they are, comma, liberty being reserved to the complainant to work out the other residuary remedies, if any, elsewhere in accordance with law. Full stop. In that connection, all contentions are kept open.
Your Lordship's permission, my lord.
Of course.
With your Lordship's permission, may I submit, they have illegally, they have taken the land, utilized, and they have spent on that land public money, our own money, nearly for 5 crore.
I have understood. Other day you said that. Other day you said that we have kept in our view. What officers can do? They are posted, they are executives, popular body takes the decision. How can we find fault with them? They are good officers. ನಾವೇನೋ ಸ್ವಲ್ಪ ಸಿಟ್ನಲ್ಲಿ ಏನೋ ಒಂದು ಮಾತಾಡ್ತೀವಿ. ಆದರೆ they are good officers. ಏನ್ ಮಾಡ್ಬೇಕು ಅವ್ರು ಹೇಳಿ ನೋಡೋಣ. What they could have done? They have done everything.
On the oral instructions of,
they have their own constraints. They have done, now they have given possession. What else they can do?
nothing.
Perhaps they have antagonized other popular bodies also, we do not know. Therefore, in fact, we have to appreciate them, to be frank with you. Anyway, that remains as a factor, which wherever you want to take, you can take that one.
In view of, Lord, one more, in view of handing over, acquisition proceeding which is initiated, 11 may not survive.
We do not know.
We will
Possession
file-
ಪಟ್ಟಾರೆ ಮುಗಿದು ಹೋಗಿದೆ.
Please.
ಆಗಿ ಹೋಗ್ಬಿಡ್ತು. ಎಕ್ವಿಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡ್ರಾಪ್ ಆದಂಗೆ ಆಗ್ತದನ ಈಗ?
ಇಲ್ಲ,
Virtually-
ಅದು ಗೊತ್ತಿಲ್ಲ ನಮಗೆ.
ಅಲ್ಲ, ಅದು notification ಇದೆ. That notification needs to be
Lapse ಆಗಿದೆ.
ಸೆಂಟೆನ್ಸ್ ಬರಿಬೇಕು. ಇಲ್ಲಿ ಏನಂತ? On 17/9/2024, we had made certain observations. Which would pale into insignificance because of the above order. ಅನ್ಕೊಂಡು ಅದಕ್ಕೆ ಲಾಸ್ಟಿಗೆ ಹಾಕ್ಬಿಡಿದ್ವಿ.
ಅಲ್ಲ, with your Lordship's permission, my lord, the notification which they have initiated.
ಅದು ನಾವೇನು ಅದ್ರ ಮೇಲೆ ನಾವು ಮಾತಾಡೋದಿಲ್ಲ.
ಅಲ್ಲ, it became
ಇದ್ರ ಮೇಲೆ
lapse
ಮಾಡ್ತೀವಿ.
ಆಗಿದೆ.
Whatever-
Otherwise-
if you say, we will, if you file a memo,
Please, madam.
we will say whether you want to drop the equation proceedings.
Please, madam.
ಕೊಡಿ, ಒಂದು ಮೆಮೊ ಕೊಡಿ.
Please.
ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ಯಾರು
City Corporation Belagavi.
appearing for the City Corporation Belgaum has filed a memo stating that the subject acquisition proceedings
EC notify ಮಾಡಿ.
are dropped.
Notify ಮಾಡಿದ್ದು EC ಮಾಡ್ಯಾರ ಸರ್. Notification is issued by Assistant Commissioner.
ಮತ್ತೆ ಅವರು ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
Please.
Submits that his client is interacting with the jurisdictional body as to whether the subject acquisition proceeding should be dropped. ಇಷ್ಟೇ ನೋಡಿ. Please ಜಾಸ್ತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ನಿಮ್ಗೆ ಇರಲ್ಲ ಅದು.
It is understand.
First, the same is placed on record.
Please. Oblige.
ಮೆಮೊ ಅನ್ನೋದು ಬೇಡ, ಸಬ್ಮಿಟ್ಸ್ ಅಂತ ಹೇಳಿ ಮಾಡ್ಬಿಟ್ಟು.
Okay.
Okay.
Oblige.
All.
My lord, I have filed an application for revival of the contempt since it is a continuous contempt. My learned friend said that he has returned back the file. He refused to take the application. Shivraj Bhai.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾಗತ್ತಾನು? Notice ಆಗಿದೆಯಾ?
He said that somebody else has filed. I'll find out who is there filed the wakalat.
ಯಾರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ಯಾರಿ?
Shivraj Belaki is there, my learned friend.
ಅಪ್ಲಿಕೇಶನ್ ಮಾಡೋಣ.
Please.
ನೋಟಿಸ್ ಹೋಗೋದು ಬೇಡವಾ?
If he is already filed wakalat.
ಅದು ರಿವೈವಲ್ ಫ್ರೆಶ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಗ್ತದೆ.
Please.
After application. ಏನ್ ಗುರು ಇದು?
Civil suit, my lords, between two parties. Suit, my lords, was one for partition and separate portion which was dismissed. Then, my lords, the RFA, my lords, was preferred. Before preferring the RFA, my lords, there was a relinquishment deed, my lords, and also the consent deed which was executed by them in favor of a person, my lords, who was subsequently purchased after the dismissal of the suit, the very same property. Then, my lords, they prosecute this regular first appeal and obtain an interim order not to alienate. In the meantime, my lords, the subsequent purchaser, my lords, has formed 5 residential plots, my lords, in the said land.
ಅವ್ರಿಗೆ ಗೊತ್ತಿರಲಿಲ್ಲನೋ ಹಿಂಗ ಅಥವಾ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ತೊಗೊಂಡ್ ಮಾಡ್ಯಾರ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಪರ್ಟ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ರು. ಆಮೇಲೆ ನಾವು ಅಪಿಯರೆನ್ಸ್ ಹಾಕಿದ್ವಿ. ಅದಾದ್ಮೇಲೆ they have alienated the property. That is, I mean, there afterwards, my lords, the regular first appeal was also dismissed for default. Then they filed an application seeking for restoration. That is the issue. He appears, my lords, for subsequent purchaser. I appear for the co-partners, my lords, who have prosecuted the suit.
ಅಲ್ಲಿ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಕೊಟ್ಟಿದ್ರಾ?
ಅದು ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಆಗಿ ನಮಗೆ ಇವ್ರಿಗೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ he was a consenting witness.
ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಇದೆಯಾ?
ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ವಿ.
ಅದು ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್?
ಹೌದು, ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್.
ಕನ್ಸೆಂಟಿಂಗ್ ವಿಟ್ನೆಸ್ ಹಾಕಿ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ? ಅಬ್ಯೂಸ್ ಆಫ್ ಲಾ.
Copies is not sir, my lord. Copies ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೆ.
ನೋಡಿ ತೋರಿಸಿ.
ಕ್ಲಿಯರ್ ಅಡ್ವೊಕೇಟ್ will
It is abuse of law. ಯಾವ್ದೋ ಕೋರ್ಟ್ ಆರ್ಡರ್ ತಗೊಂಡು ಅದು ಮೊದಲಿಗೆ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ. ವೇರ್ ಇಸ್ ದಟ್? ಕಂಟೆಂಪ್ಟ್ ನೀವೇ ಮಾಡ್ದಂಗೆ ಆಗ್ತದೆ. See that EMS GL Gaba versus ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಅದು? Take out GL Gaba versus GL Gaba versus so and so. Settle what had argued. ಏನ್ ನೀವಿದೆ ಸಿಗ್ನೇಚರ್ ಇದೇನು? ಇಲ್ಲಪ್ಪ ನಾವು ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀವಿ, ನಾಳೆ ನಿಮ್ಗೆ ತೊಂದರೆ ಆಗ್ಬೋದು. If you are a signatory to this, do you just see that?
My submission, your lordship, is they have just some impressions are there. And it is a consent deed. If they have written in the sale deed itself regarding the consent deed, then it could be considered. That definitely we can't prosecute anything. So you
cannot, otherwise your client will be abusing the process of.
Definitely, certainly, sir. Certainly. I request your lordship kindly grant little time. I will go through it and
no time will be granted. Parkade. Kodi. No time will be granted.
Copy ಕೊಡಬೇಕು.
ಅಲ್ಲ ಅಬ್ಯೂಸ್ ಮಾಡ್ಕೊತೆ. ನಿಮ್ಗೆ ಹೇಳಿರಲ್ಲ ಅವರು. ಸಮ್ಮತಿ ಪತ್ರ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ ಅದರಲ್ಲಿ?
All the parties, including them.
This complaint alleges violation of an interim order dated 30 May 2022 handed in complainant's RFA 1003222 of 2019 pending on the file of a learned single judge of this court. Correct? Single judge mundidiya?
ಇಲ್ಲ, division.
Before the coordinate bench of this court. Full stop. After service of notice, the answering respondents having entered appearance through their counsel have filed, ಇದೊಂದು ಮೆಮೊ ಹಾಕಿ ಕೊಡ್ಬೇಕು, a copy of affidavit ಜೊತೆ ಇದೆಯಾ? Have filed the reply affidavit sworn to by Mr. Arjun, son of Yellappa Hanchinal, who happens to be accused number?
Accused number 1. Arjun is accused number. My lords, he has not been married as a party. Subsequent
There are
purchasers are
eight,
not.
eight ಇದೆ ಅಲ್ರಿ.
Only.
Accused number 8 ಇದಾರಲ್ಲ ಗುರು. Fine, so. Learned counsel. ಶ್ರೀ ಗಚ್ಚಿನ್ಮಠ್. And ನೀವು appear ಆಗ್ತಾ ಇದ್ದೀರಿ ಇದರಲ್ಲಿ? ಶ್ರೀ ಬುದಿಹಾಳ್. Draw our attention to the consent witness column at page 20 of the registered sale deed dated
Nineteen six 2020 and 11/6/2020.
deeds dated 19/6/2020 and
11/6/2020 consent deed.
11/6/2020.
2020.
Copies whereof are produced along with the reply affidavit. First, it shows that the said alienation has taken place with the specific consent of complainant side.
Please, your lords. I am permitted to interrupt just.
Alienation.
That this particular person who has filed this petition is not a party to the proceedings.
He is not a party to the to the sale deed. You are not a party.
Not a party. He is there at page number 29 of my affidavit notes.
29,
29. Sammati Sakshi. Sammati Sakshi. Now Srimati Ningava Tande Adivappa Hanchinal. She is, my lords, after marriage, earlier she was Shankrava. She is now called as Ningava. Second is Kelina Hesru Shankrava. Shankrava, Kom, Kallappa.
Yaar complainant here?
Sharada Bai.
Kindly see Sharnava. Sharnava.
Marriage ಆದ್ಮೇಲೆ ರೀಕ್ರಿಸ್ಟೈನ್ ಆಗಿರ್ತದೆ.
ಆಗಿದ್ದು ಇಲ್ಲಿ ಅಲ್ಲೇ ಫಸ್ಟ್ ಇದ್ರೊಳಗೆ ಬರ್ತಿದ್ದಾರೆ ಸೇಲ್ ಡೀಡ್ ಒಳಗೆ.
That makes no sense.
Please.
Amongst Hindus, Derek says, Duncan Derek says.
But her name is no. Your lordship kindly see that Srimati Ningava Tande Adivappa Hanchinal Urf ಲಗ್ನ ಅಂಕಲಿ ಲಗ್ನವಾದ ಮೇಲೆ ಹೆಸರು ಶಂಕರವ್ವ ಕಲ್ಲಪ್ಪ ಮುಂದಿನ ಮನಿ. Whereas this.
She is the complainant.
No, complainant is Srimati Sharavva Yallappa Kardi.
Number 2 note. Complainant number 2 is Shankrava.
Sharava is Kallappa.
First is Sharavva.
Second is complainant.
Together.
My lord, verifying next week, my lord.
Together.
Yes.
ಕನ್ಸ ಇಬ್ರು ಇಲ್ಲ.
Sorry.
All right. ಹೆಸರು ಬೇರೆ ಇರೋದಕ್ಕೆ ನಾನು ಕನ್ಫ್ಯೂಸ್. Names very different ಅನ್ನೋದಕ್ಕೆ. ಮಕ್ಕಳು ಏನ್ ಬರೋದು? With the consent, inter alia of the complainants herein who have got their names rechristened after the marriage. First, a person who acquiesces to the complained action is stopped from raising the complaint. Is the settled position in the realm of contempt law. First, in view of the above, these proceedings are liable to be and accordingly dropped.
Grateful.
Yes, Vidya madam.
2 weeks time may be granted. After the dismissal of the appeal, they have filed an application seeking a stay of that. Till the appeal period.
31/7/2008, plus till the disposal of the writ appeal, plus I was protected by an order of status quo, my lords, regarding possession. Filed this application. Even before the learned single judge, after disposal of the writ petition in the presence of the counsel for the
You had
contesting I had.
of interim order.
Yes. Till the disposal of the writ appeal I had from 31/7/2008.
Objection. Respondent 4 man.
ಅವರು ಲೀವ್ ಕೇಳಿದ್ರು ಲೀವ್ ಕೊಟ್ಟಿಲ್ಲ ನಾವು ಅಲ್ವಾ? We have disposed of this. But ಲೀವ್ ಕೊಟ್ಟಿಲ್ಲ ಅರ್ಥ ಸ್ಮಾಲ್ ರಿಲೀಫ್ we can give. ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ಫುಲ್ ಬೆಂಚ್ ಆಫ್ ಆಂಧ್ರ ಪ್ರದೇಶ್ ಹೈಕೋರ್ಟ್ other day, which that BL Hansaria on writ jurisdiction has discussed this. On 8 weeks forward.
ಒಂದನೇ ತಿಂಗಳಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ, 5ನೇ ತಿಂಗಳ ಮಟ್ಟನೂ ಸುಮ್ಮನೆ ಅದು ಸ್ಟೇಟಸ್ ಕೋಡ್ ಬಗ್ಗೆ ಏನು ಮಾತಾಡೋದು?
ಸ್ಟೇಟಸ್ ಕಾರ್ಡ್ ಇದೆಯಲ್ಲ.
During the appeal period. During the appeal period.
Appeal SLP 90 days, 90 days. 3 months.
3 months.
This appeal, this appeal was has been disposed of by us. Wide order dated
11/9 minutes.
11/9/2024. First off, the appellants desire to challenge our order before the apex court, and therefore they seek some reprieve in the form of continuation of the status quo order granted by the learned single judge and later continued by this bench.
Yes.
By this court in appeal. First off, an order, an affidavit is sworn to in support of application. First off, next paragraph. Learned counsel, HCGP appearing for the official respondents and the learned private counsel appearing for the private respondent oppose the application, contending that once appeal is disposed of, court becomes functus officio. First off, there is some elements of truth in this. First off, however, law recognizes power of the court to grant a short reprieve to enable the parties to work out their remedies. First off, this view gains support from the full bench. ಯಾವ್ದದು ಗಿರೀಶ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿ ನೀನು ಫುಲ್ ಬೆಂಚ್ BL ಹನ್ಸಾರಿಯಾದಲ್ಲಿ ರೆಫರ್ ಆಗಿ ತಂದು ಕೊಡಬೇಕು ನೀವು ಮಾಡಿಕೊಂಡದ್ದು. Support of the full bench judge decision of the Andhra Pradesh High Court in so and so so and so. ಅದು ಕೊಟ್ಟರೆ ಸಿಗ್ನೇಚರ್ ಆಗ್ತದೆ, ಇರಲಿಲ್ಲ. Next paragraph. In view of the above, this application having been favored, parties are directed to maintain status quo till after the expiry of limitation for filing the SLP.
Yes.
Or SLP is filed, whichever is earlier. Please.
SLP is filed ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ it takes some time, diary number ಆಗಿ.
ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡಿದ್ದೀವಿ?
ಅಲ್ಲ, SLP is filed ಅನ್ನೋ.
ಅಲ್ಲ, you may suppose if you file SLP before, ಅವಾಗೂ ಕಂಟಿನ್ಯೂ ಮಾಡಕ ನಾವು ಬರಲ್ಲ ಅವಾಗ.
ಅದಕ್ಕೆ ಆರ್ಟಿಸಿ ಎಲ್ಲ ನಮ್ಮ ಹೆಸರು, ಇವತ್ತಿನವರೆಗೂ ಆರ್ಟಿಸಿ ನಮ್ಮ ಹೆಸರು.
ನೋಡೋಣ, ಯಾವ ಸ್ಟೇಟಸ್ ನಿಮ್ ಬರೀದ್ರೆ ನಿಮ್ಗೆ ಆಗತ್ತೆ, ನೀವೇನ್ ಕಳ್ಕೊಳ್ಳೋದಿಲ್ಲ.
అపిలేట్ మేలాడింది, సిస్ మేలాడింది, డిస్పోజ్డ్ మ్యాటర్ మేలాడింది, లార్డ్షిప్ మేలాడు, లార్డ్షిప్ హ్యాస్ మేలాడింది, డిస్పోజ్ దిస్ అపీల్ మేలాడింది, సమ్ అబ్జర్వేషన్ మేలాడి షల్ నాట్ ట్రాన్స్ఫర్ ಅಂತ ಬರ್ದಿದ್ರು ಮೇಲಾಡಿದೆ. ಎನಿ ಅಬ್ಸರ್ವೇಷನ್ ಮೇಲಾడింది ವಿತೌಟ್ ಎನಿ ರೀಸನ್ ಮೇಲಾడింది, ಟ್ರಾನ್ಸ್ಫರ್ ಮೇಲಾడింది.
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಸಪರೇಟ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಆಗ್ತದೆ. ಇದ್ರಾಗ ಹೆಂಗ್ ಬರ್ತದೆ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ.
ಅಬ್ಸರ್ವೇಷನ್ ಏನಂತ ಇದೆ?
ಈಸ್ ಮೇಲಾಡು 3.1 ಮೇಲಾಡಿದೆ, ಜಜ್ಮೆಂಟ್ 3.1 ಮೇಲಾಡಿದೆ, ಜಜ್ಮೆಂಟ್ ಮೇಲಾಡಿದೆ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಲಾಸ್ಟ್ 4 ಲೈನ್ ಮೇಲಾಡಿದೆ. Further, the apprehension of the London Council for the appeared for the appellants is that his client is likely to be transferred some
unless there are extraordinary circumstances. ನೀವು cause of action ಹೊಸ
ಅಲ್ಲ, ಏನು ಸ್ಟಾರ್ಟೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ವಿತೌಟ್ ಎನಿ ರೀಸನ್ ಮೇಲಾಡಿದೆ.
application is misconceived and therefore liable to be rejected. First, accordingly rejected. There being a fresh cause of action.
ಅಲ್ಲ, ಬರೇ ಜಜ್ಮೆಂಟ್ ತಗೊಂಡಾಗ ಅಷ್ಟೇ ಆಯ್ತು ಸ್ವಾಮಿ, ಏನಾದ್ರು
ನೆಕ್ಸ್ಟ್
wife's petition was dismissed by the trial court on the ground of please.
filed a vacating application. Lord, this present, this, ಇಲ್ಲ. Delay was there, Lord. Some delay was there. Delay was there, Lord.
ಮತ್ತೆ ಅವ್ರು ಇಲ್ದಂಗೆ ಹೆಂಗ್ ಮಾಡೋದು?
Please, Lord.
ಅಲ್ಲೇ ನೋಡಿ, ರಾಜೇಂದ್ರ ಕುಮಾರ್ ಕಟಾರಿಯಾ ಸರ್ವ್ಡ್ contempt ನಲ್ಲಿ he has remained absent. That's not a good symptom. ಅಲ್ಲಿ contempt ನಲ್ಲಿ 21.1 ನಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಕ್ಕೆ ಏನು ಅಷ್ಟೊಂದು ಕೋರ್ಟ್ ಬಗ್ಗೆ ಡಿಸ್ರಿಗಾರ್ಡ್ ಸೆಕ್ರೆಟರೀಸ್ಗೆ. ನೋಡು ಇದರಲ್ಲಿ 21.1 ನಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2.
Please take notice, accept.
Shri Girish on instructions appears for accused number 2 na?
All the respondents.
All the respondents. All right.
Senior appears to be.
I'm sorry.
Yes.
Your Lordship, before commencing, Your Lordship, I appear for respondent number 3. There was a writ filed, Your Lordship, wherein I was made a party, but notice to me was dispensed with. So the facts in the present appeal have to be objected by the respondent number 3, Your Lordship. I have sought for the documents.
Formal party, my lord. In fact, my lord, no role, my lord, of respondent number 3.
3 ದಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದ ಮೇಲೆ ಪಾರ್ಟಿ ಯಾಕೆ ಮಾಡಿದ್ವಿ?
ಅಲ್ಲ, party, he was a formal party.
ಪಾರ್ಟಿ ಮಾಡಿದ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ಡಿಸ್ಪೆನ್ಸ್ ವಿತ್ ಅನ್ನೋದು ಆಸ್ ಅನ್ ಎಕ್ಸೆಪ್ಷನ್ ಅಷ್ಟೇ. ಅದರ್ವೈಸ್ ರೆಸ್ಟಿಫಿಕೇಟ್ ಅಪ್ಲೈ ಆಗ್ತದೆ. If he is a party, whether notice is issued or not, the courts, of course, there is a divergence of opinion, but courts have
No,
generally.
he is also not, my lord. In fact, my lord, he is, my lord, what he says is.
Yes, sir, Ravi Shankar. ಎಲ್ಲ ಹೋಗಿ ಬಿಟ್ರಲ್ರಿ.
Now, what they are trying to do is, Lord, by virtue of this order, Lord, they have served, Lord, the disqualification notice. They want to disqualify them, Lord, 4 members.
ನಿಮ್ಗೆ ಟೈಮ್ ಬೇಕನಾ?
Please, Lordship, I have to bring
may I just-
documents and objections on board. Your
ಯಾರು ಡಿಸ್ಕ್ವಾಲಿಫೈ ಮಾಡೋರು ಯಾರಿಗೆ?
Allah, disqualify the directors of.
Yes, Mr. Ravi Shankar. Ha.
Lord, sir, page number 45 and page 46.
46.
Yes. Lord, this is a credit structure society. The registrar directs under section 12(6) that I will have to restrict the operation of my society to a particular territorial limits.
He has altered the territorial, he has reduced the
Territorial limits. Let's now kindly have a look at section 98I, Lords of the Karnataka Cooperative Societies Act, 2009, 98 capital I.
ಕೊಡಿ, ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಇದೆ ಕೊಡಿ. ಯಾರು ಮಾಡೋದು ಪ್ರೊಸೆಸ್ ಏನದು? ಆ ರಿಡಕ್ಷನ್ ಆಫ್ ಏರಿಯಾ.
Lords, it says that so far as credit structure cooperative societies are concerned.
98A. 98 ಏನಾ? I.
98I.
I. Restriction regarding area of a cooperative society shall have the freedom of entry and exit at any time, and there shall be no mandatory restrictions of geographical boundaries for the conduct of its business operations. Amend ಆಗಿದೆ ಏನದು? 2013 amendment.
ಹೌದು, 2013 amendment.
What do you say, brother?
That so far as 98, section 98 is concerned, my lord, it applicable only to the societies with regard to credit cooperative credit structure ಮಾತ್ರ applicable. So far as these petitioners societies
ಇವ್ರಿಗೆ apply ಆಗಲ್ವಾ?
it's not a cooperative credit
Cooperative
structure society.
structure ಇರೋರಿಗೆ ಮಾತ್ರ.
ಇರೋರಿಗೆ ಮಾತ್ರ. So my lord, that is bank, my lord. It is.
Yes, sir, Ravi Shankar, it applies to cooperative. Kindly see chapter 11 capital A. It does not apply to other societies at all.
Section, it is defined under section B2, my lord. Cooperative credit structure means includes primary agricultural credit cooperative societies by whatever name called central cooperative banks, state cooperative bank, Agricultural Rural Development Bank and State Agricultural Rural Development. It refers to banks, and those banks are regulated by the RBI regulations.
Not under
Not,
this at all.
not on this.
Only credit cooperative society is the matri apply. And you are not a credit cooperative society, brother.
Let's kindly have a look at, this is a credit structure cooperative society. What it applies to, credit structure is defined under the Act.
Defined under section B2.
B2.
2B2.
2B2. Means and includes. It's an inclusive definition. Primary agricultural credit cooperative societies, by whatever name called. Central Bank, State Bank, Agricultural Rural Development Bank, State Agricultural Rural Development Bank.
Nimdu yavadu?
Our says, yes, it's a primary credit cooperative society. Prathamika Krushi Pattina Sahakara Sangha Niyamita. Agricultural Credit Structure Society minutes.
It PKPS, Primary Kushipati Sakari Sangha.
Yes, Pattina means credit.
Credit cooperative society. ಪ್ರಾಥಮಿಕ ಅಪಾಯಗಳು ಅಂತೇಳಿದೆ ಚಾಪ್ಟರ್ 11 ಕ್ಯಾಪಿಟಲ್ ಎ ದಲ್ಲಿ ಎಲ್ಲಾ ಕ್ರೆಡಿಟ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಕವರ್ ಆಗಿದೆ. ಜಸ್ಟಿಸ್ ರಾಮನಾಥ್ ಹೆಗಡೆ ಅವರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. ಆಲ್ ಕೋಆಪರೇಟಿವ್ಸ್ ಕ್ರೆಡಿಟ್ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟೀಸ್ ಆರ್ ಕವರ್ಡ್ ಅಂಡರ್ 98 ಐ ಅಂತ I think okay, section says it's free for all. How can that be restricted?
I may take your lordship's kind attention to section 106 of this act, your lordship.
106.
106, your lordship. This provides for an appeal, and this provides for an appeal, your lordship.
We'll look into that. Please, legislative intent is it should be free. How can he make an order restricting that one? Correct. Correct.
My submission is that, your lordship, there are pleadings made in the writ petition.
Alternative remedy is only judicial intervention, the invention. ಅದನ್ನ ಬರ ಆಮೇಲೆ ಪ್ಯೂರ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಅಲ್ಲಿ ಏನಪ್ಪಾ ಈಗ ಫ್ಯಾಕ್ಟ್ಸ್ ಇದೆ ಅಡ್ಜುಡಿಕೇಟ್ ಮಾಡಬೇಕು ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಪ್ಯೂರ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಬೇರೆ ಏನಿಲ್ಲ ಯಾವ್ದು
ವರ್ಲ್ಪೂಲ್ ಕಾರ್ಪೊರೇಷನ್ಸ್ ಕೇಸ್
ಅಲ್ವಾ
Then counsel for the appellant points out that section 98I not restrict the area of operation for the
society, great cooperative society, great
structure. Cooperative societies, the cooperative structure. Stop. Review of the said submission matter requires detailed consideration. Interim order stay of the what stay, which order?
Stay of annexure F. Annexure F.
Stay of the stay of the order dated 11/1/2015 passed by the annexure F. And order of the single judge.
Lordship, may I seek liberty?
Great. Objections, if any, to the writ petition.
Please.
Because he has not made objections to the writ petition. First, I'll condone accepting the
I seek.
is interpreting the appeal.
I appear to respond to Milord. I may file objection. And there is a delay of 132 days in filing appeal.
My lord, corporation appeal, my lord. There is a delay of 553 days.
Merit ಮೇಲೆ ಏನಿದೆ?
Merit ಮೇಲೆ, yes. My lord, the writ petition is also dismissed on a delay, my lords. On a ground that, my lord, the order which is questioned in a writ petition is, my lord, past last 6.5 years delay in filing the writ petition. May I make submissions of the, my lord, This is the case wherein, my lord, the tribunal at the time of considering 33 2B application,
33 2B of ID.
ID Act, my lords, wherein, my lord, we have sought approval of the, my lord, dismissal of the employee. At the time of considering that application, my lord, hold issue number 1 negative, and my lord, immediately, my lord, IA has been filed for interim maintenance, interim payment of wages, my lords. That IA came to be allowed. Now, my lords, let me kindly see in the entire ID Act, there is no any such, my lord, procedure where, my lord, interim wages can be given to the employees.
But there is one judgment.
I'll come.
There is one judgment.
Mysore
of,
Bank.
huh?
Mysore.
There is one judgment.
Yes.
Where interim order can be granted. Interim orders are now interim orders are granted after
I'll come
Bhopal
to
gas
that. I'll
tragedy
come
matter.
to that. It is there, my lord, in the Industrial Dispute Standing Orders Act, wherein I'll come to that. In the Act itself, Section 13 says this Act is not applicable to the KSRTC, and that is there is proviso in the Act itself. Now that Act which
You have to stop after one sentence. Admele nilbek. Now process madad bedwa.
Sorry, next.
1946 Act is not applicable.
Allah, that Standing Orders Act is not.
Act is 1946 Act adu.
Houdu.
It is not
Only,
applicable to.
my lord, why that standing order is not applicable to those industries
Covered
which,
under the better disciplinary, better service conditions under the.
those
Act.
who are not adopted those standing orders, my lords. There is a standing orders which certain welfare beings has to be taken place and adopted in their regulations. The chartered of
Standing orders act kudi. Model standing orders so apply agalwa.
illa nam separated.
But the standing orders
We are
should
having
apply on their
we are
own.
having our own separate independent standing orders which has been approved and.
Adralli illa antana anta provision illa.
I'll take it to my lord's kind permission to that act itself, where what is that 10A says in that standing orders. 10A, my lords, which says
10 idea section.
10A of the act says that, my lord, interim orders maintenance can be given.
10A idea section idea. 10 is.
How the standing orders
10A.
1001.
Payment of subsistence allowance.
Yes, subsistence allowances. That they say that only if, my lords, issue number 1 is hold negative. And section 13, my lords.
10A3.
10A3.
3.
Notwithstanding anything contained in this foregoing provisions of this section, where provisions relating to payment of subsistence allowance under any other law for the time being in a force of in any state or
More beneficial
than the provisions.
More beneficial ididdu.
Now, may I take my lord's kind effect conditions, my lords? 12 may kindly be.
There are judgments. See, two things.
Yes, my lords.
It goes against you now.
I'll convince my lordship.
So there is, if you have regulations which are more beneficial to the workman, they will be applicable.
No,
Not
my
absence of this one. The very provision of this act.
Yes, my lords.
This act is made to protect those employees in the absence of any, not only in the absence of contra provision, your provision should provide for a better condition.
My lords, may I take my lords? There is a provision which says that, my lords, delegation of power, section 13 interpretation, 14, my lord, 14,
Section?
13. There is a separate provision which says that the act is not applicable to the, my lord, KSRTC, road transport and other things.
13B.
13B.
Okay. Like not to apply to certain industry establishment. Nothing in this will apply to industry establishment. So far, been employed persons to whom the
Mark ಮಾಡ್ಬೇಕಿತ್ತು ನೋಡಿ ನಿನ್ನೆ.
CCA rules apply agaditre, revised leave rules, civil service regulations, civil defense,
13B, my lords, sorry.
the railway establishment code, or any other rules or regulations that may be notified in this behalf by the appropriate government in the official gazette. Antorsi.
My lord, nothing in this act shall apply to
We have
an
read that now.
industrial establishment so far as.
We have read that now. Unless there is a notification published in the official gazette, a notification ಬೇಕಾಗ್ತದೆ. Road Transport Corporation Act signs. Road Transport Corporation Act.
ಇವಲ್ಲ.
96(7) KLJ.
Yes, ma'am. That, my lord,
ಅದು ನೋಡ್ಕೊಂಬರ್ಬೇಕು. Already there is a division bench decision
yes,
in your
division,
favor.
I'll come, division bench has, my lord, relied 3 decisions of the Supreme Courts where.
They are in your favor only. You want to still argue?
Judgments ಇದಲ್ಲ ಅಷ್ಟಿತ್ವಲ್ಲ. Okay, ಇಲ್ಲ, sorry. Yes, I'm having yours.
Notice ಹೋಗಿ ಬರ್ರಿ.
ಎಲ್ಲ ಕೆಳಗಿಟ್ಕೊಂಡಿನಿ.